Hi, I'm Mark Weiker, education attorney with the law firm of Albite Weiker, LLP. On Monday, July 6th, the Student and Exchange Visitor Program, which is SEVP, which is a program operated by ICE and the U.S. Department of Homeland Security, announced that it would require non-immigrant students on F1 and M1 visas to attend at least some form of in-person classes in the fall in order to legally stay in the country. F1 visas are issued for academic courses, and M1 visas are issued for non-academic or vocational training. So the general rule is that non-immigrant students on these visas must attend in-person classes, except that they can take one course, up to one course, which is also up to 3 credit hours online. But as a result of COVID-19 in the spring of 2020, the program announced a temporary exemption to that requirement, which allowed students to continue in courses online, fully online, after the schools were forced to close due to the pandemic. This applied to the spring and summer semesters of 2020 only. Now, on Monday, the program issued clarification under a directive that confirmed that they are again requiring F1 and M1 visa holders to attend some form of in-person classes in the fall. Many schools, including Harvard and MIT, who filed a lawsuit against Homeland Security and ICE today, believe that the directive was intended to pressure universities to resume in-person classes in the fall, regardless of the health risk that it poses to all of its students. Under the directive, any school offering a hybrid model, so some mix of online and in-person classes, must certify that the program is not entirely online and that the student holding the visa is otherwise in compliance with the rule. If a student is not in compliance, they must leave the country and drop the course altogether, leave the country and continue courses online at home or abroad, or transfer to a school in the U.S. that holds in-person courses. As you can imagine, continuing outside of the U.S. could be problematic for some students because they may not have stable internet access from home or abroad. Time differences could make the courses online impractical, and they would, of course, lose the educational experience that they were seeking in the U.S. This directive can also be problematic for universities, as the lawsuit indicates, because it pressures universities to adopt a hybrid model or fully in-person courses, regardless of the risk posed to its students by the pandemic. Universities also stand to lose a large number of international students who often pay full tuition, and this can equate to a large chunk of the university budget. Even transferring schools for students can be challenging because some scholarships may not transfer from school to school, and finding a school with the same program and with in-person classes could be difficult. We believe that this directive is not good for students, it's not good for universities, and it's not good for the country. We would encourage ICE and the U.S. Department of Homeland Security to reconsider the rule. We believe there are ways to incentivize in-person classes that does not involve punishing these talented students.